Thanks. We really appreciate you all coming out for this panel. It is Prosecutors Gone Wild, not Girls Gone Wild. So if you're in the wrong room, you could sort of quietly step out. Actually, in all seriousness, we have a really distinguished panel here today, and we're going to be focused on the question of have prosecutors gone wild, and if so, how can they be tamed, to borrow from somebody's article in National Review. As one of our panelists has written, prosecutorial misconduct is one of the most pernicious things. It's very difficult to uncover. The damage to public confidence in our judicial system is extraordinary, and it just does violence to the rule of law. That's not to say that most prosecutors have gone wild. Most prosecutors strive to do their jobs with honor, fairness, and integrity. They want to seek justice, not get notches on a belt. And sometimes those prosecutors have to do some things that are very unpopular, bring cases where folks think that those cases should not be brought, and decline to bring cases when that's what justice requires. So today we're gonna talk about the rogues, prosecutors that haven't kept faith with their obligations under the law, and we have a really distinguished panel to help us through the discussion. All the way on the end to my far right, which is always a good place to be, is John Funn. John Funn is national affairs columnist for National Review and an on-air contributor for Fox News. He worked for the Wall Street Journal for more than 2 decades, starting in 1984, and was a member of the newspaper's editorial board from 1995 to 2001. He's written for Esquire, Reader's Digest, Reason, and The New Republic. In 2004, he wrote Stealing Elections, How Voter Fraud Threatens Our Democracy, put in a plug there. And he's written 2 other books with someone who's in the audience
Hans
here.
von Spakovsky.
There he is. One is Who's Counting? How Fraudsters and Bureaucrats Put Your Vote at Risk. And the most recent, which I hope he'll talk about a little bit, is Obama's Enforcer, Eric Holder's Justice Department. Next to John is Sidney Powell. Sidney is an extraordinary appellate lawyer. She has been lead counsel in more than 500 federal appeals, resulting in more than 180 published decisions. She represents clients in complex federal appeals and consults in complex federal litigation in civil and selective criminal cases. She's a Phi Beta Kappa graduate of the University of North Carolina, where she also attended law school. She is our prosecutor on the panel. Ms. Powell was the youngest assistant U.S. attorney in the country when she began working with the U.S. Attorney's Office in the Western District of Texas. She's also served as an assistant U.S. attorney for the Eastern District of Virginia. She is in the process of working on a book entitled License to Lie. It's finished now.
Published and has been selling briskly.
Excellent. So we'll hear more about that, I'm sure, as well. And then last, and I don't know if you've written any books yet. I did. You did. So we'll get to that in just a second. Then if I can find your bio. Clark Neily. Clark is a senior attorney with the Institute for Justice. He joined the Institute for Justice in 2000 and litigates economic liberty, property rights, school choice, First Amendment, and other constitutional cases in both federal and state courts. He served as counsel recently in a successful challenge to Nevada's monopolistic limousine licensing practices, which effectively prevented small business persons from operating their own limousine services in the Las Vegas area. Uber probably wants somebody like you on their side. Clark is also a member of the Institute's very important school choice team. Besides representing parents and children in defense of Florida's Opportunity Scholarship Program and school choice programs in Arizona, Maine, Milwaukee, and elsewhere, he's participated in many debates in support of school choice. Clark also served as co-counsel for the plaintiffs in District of Columbia versus Heller, which was the historic case in which the Supreme Court announced for the first time that the Second Amendment protects an individual right to own a gun for self-defense. He is a graduate of the University of Texas Law School, where he was chief articles editor of the Texas Law Review, and he clerked for Judge Royce Lamberth on the U.S. District Court for the District of Columbia. Tell me about the book you wrote, because I don't see it listed
Got
here.
an old bio, but that's, it's called Terms of Engagement, How Our Courts Should Enforce the Constitution's Promise of Limited Government.
Excellent. Well, we're going to hear more about that as well. But just to start, I wanted to ask John to maybe help us paint the picture, describe what we're talking about when we talk about prosecutors gone wild.
Sure, and I appreciate it. And as for where, actually, I think my microphone is working, right?
Sounds like it.
Okay, it's working. Actually, I appreciate the pitch for my political persuasion. I grew up in California, and they used to say that I was so conservative that my right hand didn't know what my extreme right hand was doing. Actually, I come from a very long line of law enforcement people in my family. My uncle was a prosecutor. My grandfather was a JAG officer in the Air Force. And my brother was the deputy chief of police in Tucson for many years. He was actually the liaison with the Border Patrol for 10 to 15 years, which prompts a lot of my interest in immigration issues. So I appreciate the job that prosecutors do, and it's a tough one. You're dealing with an awful lot of people who are guilty, and you're dealing with restraints and constraints in which a lot of them are going to get off or get far reduced punishments than they deserve. And there's always this tension there. You may know someone is guilty, but in our system you have to prove they're guilty. And also, of course, there has to be prosecutorial discretion. You can't go after every bad guy or gal. You have to pick and choose. Now that invests enormous power and discretion in prosecutors. That's why we tend to try to place very clear ethical guidelines. The Department of Justice's guidelines are very significant in this, on what prosecutorial behavior can be, and hopefully we set up a series of steps that tends to mitigate against prosecutorial abuse. I think it's fair to say that in the last generation, many people, and not just old-timers, will say, clearly something has gone wrong. I first encountered this in the case of Senator Ted Stevens from Alaska, who was, contrary to Justice Department guidelines in 2008, indicted 9 days before the general election in which he was a candidate. I cannot think of a more political decision. Now, I was not a fan of Senator Stevens. He was the great practitioner of earmarks and pork barrel in the Senate. I can give you a list of the editorials I wrote against him, a yard long. But the strength of our system is even people you don't like deserve justice and deserve the civil liberties protections that are accorded all Americans. That's the key. Our system works just as with free speech for all, not just the people you agree with. Prosecutorial ethical behavior for everyone. That's the key to our system. There's a famous expression in the poem, The Incredible Bread Machine, which is about the unfair prosecution of a businessman from the Antitrust Division of the Department of Justice. And at the end, this guy who's invented a machine that bakes bread for a penny a loaf, but the competitors go after him, they charge him with monopoly, they charge him with collusion, they charge him with unfair competition. He's about to be sentenced by the judge. He has a final word and he says, "Why are you doing this to me?" And the judge looks down at him and says, "The rule of law in complex times has proved itself deficient. We much prefer now the rule of men. It's vastly more efficient." What divides us in this country, and I've studied the systems of many other countries, is we adhere to the rule of law, not to the rule of men. If we fail to do that, we have lost our country. Now, in the case of Senator Stevens, it became clear there was an outrageous series of abuses. Not just was he indicted 9 days before the election, which led to his defeat by a couple of thousand votes, and that ultimately the senator who replaced him ultimately cast the deciding vote for Obamacare. So if you don't think these things can't have dramatic political consequences, Senator Begich, who was defeated in the next election, that's how weak he was as a candidate, he was defeated in 2014, but in 2010 he cast the deciding vote for Obamacare and made Obamacare the law of the land. But leaving that aside, the abuses against Senator Stevens, the withholding of evidence, the suborning of witnesses, the creation of false evidence, were so egregious that it led to a federal judge basically stepping in. I think it was Judge Emmett Sullivan, stepping in and basically taking over the investigation and issuing a scathing report. Even so, this is the key, the punishment meted out to those prosecutors in the Justice Department who were at the heart of this scandal was insignificant compared to what they would have done. So then we move on to some of the cases that Hans von Spakovsky and I discussed in our book, Obama's Enforcer, the Eric Holder Justice Department. Rather than learn lessons from prosecutorial abuse in the Ted Stevens case, which Holder could properly have said happened under the Bush administration, Holder instead has sat there and allowed prosecutorial abuse after prosecutorial abuse to take place. A perfect example of that would be there's a division of the Justice Department that handles environmental crimes. How many of you have heard of the raid on Gibson Guitar? This was one of the most chilling episodes in American history. A pre-dawn raid by armed federal SWAT teams of Gibson Guitar. They were in search of evidence because somebody had given them a tip that Gibson Guitar had imported wood that was from an endangered species from Madagascar and India. They confiscated their entire warehouse of such wood. They basically shut down the production line for months. Only months later was it revealed that Gibson Guitar had signed statements in English from the Madagascari and the Indian governments giving them the right to import that wood. And apparently the original tip sending them this way came from a competitor, the C.H. Martin Company, the guitar company. Now, of course, it's a complete coincidence that the Gibson Guitar Company is a frequent contributor to Republican candidates, and the Martin Company is a very well-known contributor to Democratic candidates. That is a complete coincidence, of course. But apparently what Martin Company was out was they wanted to get that wood because it would have been government property if it had remained seized, and it would have been put up for auction. So finally, the Justice Department had to surrender, and there was basically a no-muss, no-fuss agreement that was set. But an outrageous example of almost shutting down a business, one of the most storied and respected American businesses. John Lennon, RuPaul, everybody who has strummed a guitar has used a Gibson guitar.
Well, let me ask, Sidney, John's a journalist, you're a former prosecutor. Is the problem really that bad?
It is really that bad. I love law enforcement. I spent 10 years in it. I love federal prosecutors. There are scads of them out there really working hard every day to do the right thing and to do it the right way. But by God, when somebody walks in a court of the United States of America and says, "My name is Sidney Powell, I represent the United States," and threatens the life, liberty, and property of a fellow human being, they have a moral, a legal, and an ethical obligation to do it right and to get it right. And that means following the law, not abusing the law. So it sends me absolutely over the edge when I see prosecutors or law enforcement abusing the people that they have frankly been sworn to protect. It is not acceptable. There is far too much of it. The Innocence Project alone within the last few years has freed over 1,300 people from lengthy terms of imprisonment, mainly from our state court systems, and most wrongful convictions are attributable to prosecutorial misconduct. The exoneration, the National Registry of Exonerations, has thousands of people on it who have been exonerated. Approximately 10% of those are in federal cases. I know there are people sitting in our federal prisons right now who did not commit the crime with which they were charged, may not have committed a crime at all, and are victims of over-criminalization. This country has gone berserk on trying to criminalize business conduct, things that are not criminal at all, and prosecute people on multiple counts for the same offense.
Can you talk a little bit more about over-criminalization and the role of, say, lawmakers in this problem?
Sure. Lawmakers have passed so many statutes that it's fairly common now for a federal prosecutor, anyone he or she is angry with, can be indicted for 3 or 4 felony offenses. A good example of that is a case the Supreme Court just reversed this week, the Yates case. A fisherman, a commercial fisherman, had been out on a boat for 6 days catching grouper. One of the wildlife people out patrolling saw what they thought were 3 undersized grouper on a hook at the edge of his boat and decided to inspect further. and found a grand total of 72 grouper that, when measured with a measuring tape, came out to be 18.75 inches to 20 inches. 20 inches was the minimum. So those 72 groupers should have been thrown back overboard. They gave him a citation, which was perfectly valid for the fishing infraction. That would have meant his license could have been suspended, or he could have been assessed a small fine. They also told him to keep those fish in a separate container when he came to port. Well, he wasn't coming to port for 4 more days, and he sold fish to earn his living, and I gather he wasn't disputing the fact that there were 72 undersized fish on his boat. So he threw the little fish overboard. 32 months later, a federal prosecutor indicted him on at least 3 federal felonies for throwing the fish back in the ocean. He was indicted for making a false statement to a law enforcement officer, carrying a penalty of 5 years. He was indicted for destroying property that could be seized, which carried, I think, a penalty of 10 years. And he was indicted under Sarbanes-Oxley destruction of evidence provision, which includes any tangible object and carries a penalty of up to 20 years.
Wait, isn't Sarbanes-Oxley a Wall Street fraud law? What does it have to do with fishing?
It is a Wall Street fraud law. It had nothing to do with fishing.
It allows prosecutors to fish.
Yes. It allows prosecutors to sink the hook in deep and throw the defendant overboard and into prison for 20 years because it contained the words tangible object, destruction of any tangible object. So the overly aggressive prosecutor and the U.S. attorney took the words tangible object and included that to mean fish. Never mind, it's in a statute, Sarbanes-Oxley, that was obviously designed to apply to financial crimes, and indicted the man and could have sentenced him to 20 years in prison. He got a 30-day sentence, 32 months and more after. And on top of that, by the time they indicted him, it wasn't even a crime to have an 18-inch grouper. I mean, and it wasn't a crime to begin with. It wasn't a civil fishing violation to have an 18-inch grouper. So there was no violation at all by the time he did it, but they could indict him and did indict him for 3 felony counts of destruction of evidence for putting the fish back in the water.
I'm almost sold that there's a real problem here. But Clark, maybe help me out and tell me it's not quite that bad, and certainly that it's not slipping over to the civil side.
It's worse than that bad. The 2 most important things you need to know about the status of prosecutors in America is that they are completely unaccountable. You will not identify, and you cannot identify, a less accountable occupation than prosecutor. There isn't one. All of us lawyers who are not prosecutors, if we mess up, if we commit malpractice, we can be sued. Prosecutors can never be sued for anything they do on the job. The Supreme Court held that in 1976. That is an astonishing exemption from accountability. That includes, by the way, framing people, suborning perjury, and deliberately putting people in jail they know to be innocent. They can't even be sued for that. That's astonishing. And committing perjury themselves, which happens. The other thing to understand is the complete lack of seriousness within the prosecutorial community about identifying wrongdoers and punishing them. I thought I'd work in a fact about sharks. It seems relevant. In 2013, there were 10 fatal shark attacks in the entire world out of 6.5 billion people. So one of the great irrational fears people have is being attacked by a shark. Don't worry, it'll never happen. You know what's even rarer than being killed by a shark? Is a prosecutor going to jail for misconduct. It's happened once in the history of this country that I've been able to determine, and it was recently, in November of 2013. A sitting judge in Texas who had been a district attorney, a county district attorney, withheld evidence in a murder case. They prosecuted the husband, whose wife was beaten to death. The prosecutor deliberately withheld exculpatory evidence, including DNA material that would have exonerated the husband. He knew about it, and he withheld it on purpose to secure the conviction, and that man went to jail for 25 years. They pulled that judge out of his courthouse. They finally did an investigation. The man was exonerated. That judge was brought up on criminal charges. Can you think of anything worse to do to another person than to frame them for murder, to deliberately withhold exculpatory evidence, and send them to jail for 25 years. Can you imagine a bigger breach of trust? What do you suppose was the penalty that this former prosecutor faced when he was convicted of this conduct? 5 days in jail. 1 day for every 5 years of this man's life that he cost. That is how serious we are in this country about reining in prosecutorial misconduct. Not serious at all. If you're a prosecutor and you deliberately withhold evidence and somebody goes to jail as a result who is innocent, you probably have a greater chance of being struck by lightning than you do of being sanctioned in any meaningful way. Why? Because prosecutors are entirely self-policing. They are not accountable, as I said, in any civil lawsuit. They are not criminally accountable in any meaningful way. The only way to get rid of bad prosecutors is for other prosecutors to go after them, and they take care of their own. Make no mistake about it. Is it that bad? Yeah, it's that bad. Is it bleeding over into the civil side? Absolutely. I work for a public interest firm called the Institute for Justice, and we have recently gotten into civil forfeiture, something that's been in the news quite a bit lately. You may have heard of it. Civil forfeiture is a process by which the government can accuse you of wrongdoing and then take your property without ever proving that you committed any wrongdoing. They simply allege it. A police officer or other law enforcement agent takes your property on probable cause alone, which is nothing. And then instead of actually proving in a criminal court of law that you committed the misconduct they have accused you of, they just allege it. And the burdens shift. There's a tremendously complex process by which you essentially have to prove your own innocence. You have to prove the innocence of the property that they've seized. And by the way, you really do have to prove the innocence of the property, because under this old-fashioned way of litigating these cases, they actually sue your property, not you. So it'll be United States versus one briefcase containing $100,031, or United States versus one 1976 Ford Eldorado. That's the name of the case. They sue your property, and then you have to intervene in the lawsuit and prove that the property was innocent of whatever wrongdoing they've accused. And the misbehavior of prosecutors that we've encountered in these cases is mind-boggling. I want to tell you about just one case. It's got a happy ending, which I'll get to, so we don't all feel depressed. The government stole about $500,000 from three brothers in Long Island, the Hirsch brothers, who were operating basically a convenience store supply company. They supplied candy and Cokes and cigarettes and things to convenience stores. There is an obscure federal law that requires banks to report cash transactions above $10,000. There's another law that makes it illegal to structure or break up your cash transactions into amounts less than $10,000 for the purpose of evading that reporting requirement. And the government has been using this structuring charge to go around stealing money from innocent people. We've represented more than half a dozen in court, and we've talked to dozens more. The Hirsch brothers had a cash business. That's just the way their business worked. They did a lot of cash. The convenience stores do cash business. Convenience stores pay for their stock with cash. So these guys are always going to the bank. Banks don't like filling out the forms, so they would refuse to take cash deposits of more than $10,000. A pattern was established. The federal government used that pattern to seize $500,000 from these guys. There is something called the Civil Asset Forfeiture Reform Act of 2000. Don't get hung up on the terminology. We were all supposed to celebrate when that was passed because it was this big reform of the asset forfeiture process. By the way, there is no way to reform civil asset forfeiture. It's immoral and unconstitutional, and the way to reform it is to get rid of it. Subject for another day. What these prosecutors did was they held on to this $500,000 and failed to initiate any legal process, as they were required to do under the law, by which the brothers could get their property back. Literally, the money just went into a kind of a black site. There was no process by which they could get the money back. The prosecutors dodged the entire statutory framework that enables citizens to challenge the unjust forfeiture of their money, and the government held on to that money for 2 years. It was the entire operating account of this company. And you know what they were waiting for? They were waiting for these guys to knuckle under and either go bankrupt or come crawling on their hands and knees to the government to plead for maybe half of that money back, because that's how they work. That's how these forfeitures work. The government takes your money, and then they initiate settlement discussions. And the settlement discussions go something like this. It's a nice story you got there. Be ashamed to see something happen to it. And we've all heard that before.
Wow. So let's talk about what could be done about the problem that you've all agreed is a significant one. I would think that the Justice Department would have guidelines and procedures to police its own, John, and I was wondering maybe if you could talk about that, and maybe, Sidney, you could talk about that as well, or about the role of judges and whether judges are speaking out on this topic.
Guidelines without enforcement are meaningless if no one sees anyone punished. If increasingly people of the Justice Department act with impunity, and in some cases are even promoted or rewarded or given bonuses or commendations, you have to ask yourself, why am I following these guidelines? If no one is punished effectively, the corruption, the rot, extends throughout the entire institution. Now, in theory, several steps removed from the guidelines, there's the Inspector General. Every cabinet and major federal agency has an Inspector General who's an independent presidential appointee. Over 70% of the Inspector Generals we have today are Obama appointees confirmed by a Democratic Senate. So these are not part of the vast right-wing conspiracy.
There was one agency that didn't have an IG for about 4 years. It was the State Department.
Yes. Funny how that works.
Yeah, really.
And the Clinton Foundation was a beneficiary of that lapse. But here's the problem with the Inspector Generals. You may not have heard about this, but over 2/3 of the Inspector Generals, the majority of whom were Obama appointees confirmed by a Democratic Senate, recently wrote Congress saying we can no longer do our jobs because the departments we work for just ignore what we want. They don't give us documents. The most vociferous was Mr. Horowitz at the Justice Department. He's the Inspector General there, Michael Horowitz, who said, in 4 separate cases, I have been not been given access to documents that all of my predecessors would have been given access to. In other words, the standard has changed. And he says, I cannot complete my work on these pending investigations. So if the guidelines aren't enforced, people aren't punished, and even the Inspector General, who's the outside watchdog, can't do his job because the Justice Department won't cooperate, you have a perfect storm of corruption, malfeasance, and the abandonment of professional responsibility.
The guidelines that the Department of Justice has are no more meaningful than the prosecutors and the intent and personal integrity they have to follow the rules. The Department of Justice Office of Professional Responsibilities has simply circled the wagon in defense of every prosecutor that's been accused of anything in the last 5 or 6 years, including the Stevens prosecutors, who by the independent counsel appointed by Judge Sullivan were found to have pervasively, intentionally, and systematically withheld evidence that resulted in the jury verdict against Senator Stevens. So there are published findings of that. My book, License to Lie, goes into that at length, the Stevens case and also the Merrill cases as a result of the Enron task force work. The Enron task force prosecutors that I discuss in my book were not only not disciplined for anything, even though the Fifth Circuit found they plainly suppressed evidence favorable to the defense, they were promoted to Chief White House Counsel, Obama's longest-serving Chief White House Counsel, who was the front-runner for Attorney General until John Stossel did a 6-minute feature on my book, and the next day she pulled her name from the list. Another one is now head of our criminal division of the Department of Justice, Leslie Caldwell, who destroyed Arthur Anderson and 85,000 jobs, only to be reversed by the Supreme Court 9-0.
Years later.
Because it was shocking how little culpability the jury instructions they had crammed down the judge's throat required, and because what they had been charged with doing wasn't an offense at the time. And the other one became general counsel of the FBI, Andrew Weissman, who has now been moved to head the corporate fraud section at the Department of Justice. These people actually yellow highlighted evidence that showed 4 Merrill Lynch executives were innocent, hid that from us for 6 years, while the 4 Merrill Lynch executives went to prison for a year on an indictment that did not even state a criminal offense.
Sidney, do you think judges are not doing their job to police?
Judges are not doing their job. Judge Alex Kaczynski, the chief judge of the Ninth Circuit, wrote a dissental in United States versus Olson, saying that there is an epidemic of Brady violations abroad in the land and that judges must put a stop to it. To that end, I have drafted a Brady compliance order that any state or federal judge could enter tomorrow in every criminal case that it would at least compel immediate production to the defense of evidence favorable to the defense, which is what should be had. It's basically an open file order with a revolving requirement that they produce every 21 days, because that's what a prosecutor ought to do to get ready for his case anyway. He needs to know everything that's in his file.
Clark, do you have any ideas on the policy front, ways we could address the problem?
Yeah, first of all, some transparency. Let me share a couple of facts with you. The Justice Department's Office of Professional Responsibility, which is nominally in charge of disciplining prosecutors, has a standing policy of refusing to identify by name prosecutors who have been determined to have committed intentional misconduct, including in some cases misconduct that resulted in the conviction of an innocent person. And the reason why OPR refuses to identify prosecutors who have been determined to have deliberately committed misconduct is because of their respect for the prosecutor's privacy rights. That summarizes the attitude of this department in one factoid. They do not care about getting rid of the bad apples. They're unserious about it. They care more about circling wagons and protecting the professional careers and reputations of their colleagues than they do of ensuring that justice is administered even-handedly. That is a standing policy of the office that is charged with enforcing prosecutorial ethics. Of course they've lost their way. Of course they don't take seriously their obligation to obey their ethical responsibilities. I'll just throw out a couple more factoids here. In 2001, of 201 confirmed cases of prosecutorial misconduct by DOJ attorneys, only one attorney was temporarily barred from practicing. There were no other sanctions. And again, we don't even know the names of these people because the OPR will not release it. So what we've got is a complete lack of transparency, as I said before, and a complete lack of seriousness about identifying and getting rid of the bad apples. Here's one policy suggestion. You know who's really, really good at identifying bad apples? Is insurance companies who have to pay claims based on the harm that those bad apples do. They're really good at identifying the bad ones, whether it's bad doctors, bad lawyers, or bad anybody else. So if we were to get rid of absolute prosecutorial immunity and allow at least prosecutors to be sued at least under some circumstances, they would have to go and get malpractice coverage like anybody else does, and you would have the whole mechanism of this very, very accomplished and, an insurance industry with a great deal of practice at rooting out people who cost them money. And what we're talking about here is people who abandon their ethical obligations, who create harms that insurance companies have to pay for. That would be an excellent enforcement mechanism, and we don't have it. Why not? Because the Supreme Court took it upon itself to simply exempt all prosecutors from all civil liability. What more powerful signal could we possibly send prosecutors that we are utterly, utterly unserious about requiring them to adhere to their professional obligations than to exempt them and them alone from having to pay for the harms that they cause? No other profession in the country gets that kind of kid glove treatment.
We've done a lot of talking, and I think I'm convinced that maybe there's something we ought to look at, even though I think in the main most prosecutors want to do the right thing. But you're right to highlight the issue. What do people in the audience think? There must be people who have questions. Why don't we start over here? Do we need to pass a mic or not? I'm not really sure.
If they can stand when they ask their question, that helps it carry better.
What we've heard, it sounds like we have a structure of law in our Inspector General system. My question is, why should Congress defund Inspector General and create their own?
Why shouldn't Congress defund
Go ahead.
Inspector Generals that exist now and have them through the program reporting to Congress?
I think they could probably just change the reporting mechanism and maybe beef up those offices more. And for some reason, the Inspector General for Department of Justice is the weakest of all. And John's right, 42 Inspector Generals wrote an open letter to Congress complaining about the lack of transparency and the failure of this administration to cooperate with them in the performance of their duties.
I question whether or not Congress, look, I'm a believer in the separation of powers. I question whether Congress which already has oversight powers, needs to appoint the inspector generals. The inspector general system is flawed, but it can be fixed without being trashed. It worked under Jimmy Carter. It worked under Ronald Reagan. It worked surprisingly well under Bill Clinton. It worked under George W. Bush. It seems to have only worked under the Saul Alinsky administration of Barack Obama. Well, I understand that, but Congress has limited resources and limited time. There are a lot of fish that Congress has to fry. I don't think you want to pass an Inspector General reform bill that is going to be the subject of a certain veto when you have other things you have to do and other oversight functions you have to carry out. Next question.
Another question. Why don't we go all the way to the back in black dress?
Hi, quick comment and then a question. First of all, we're from Phoenix, and a guy who used to be one of the managers at the DOJ in Phoenix recently changed jobs, and he told a bunch of us at a Federal Society party that they would always get memos coming down from the Obama administration, target this enemy, and he would laugh about it. In meetings, he actually would say, this is the Department of Social Justice, not the Department of Justice. So that's that pure evidence right there. And then I had a question.
Can you see me after the meeting? I'd like to talk to you about that. No. I'm not trying to drag you into it. Your name's not going to be involved.
And my question is, John Clerk might actually know what happened to me. Clerk Neily will find this very interesting. I ended up being a prosecutor for a while, and I never even wanted to be one, but I'm a conservative prosecutor. So they came after us, the district attorney I was working for, they came after him hard. They just barred him. The state bar went after him. I've been fighting it for 5 years now, and I'm not even a prosecutor anymore. But basically my question is, what do we do to take on state bar prosecutors that are coming and targeting regular conservative attorneys? I know in Arizona we're trying to get a law passed that would get rid of the mandatory bar.
Anybody have any views on that? Abuses by state bar authorities?
In Texas, they haven't been doing much of anything against any prosecutors, conservative or otherwise. In fact, it was the Michael Morton case in Texas that we were talking about earlier, where the prosecutor who became the state court judge only got 5 days in jail for Michael Morton's 25 years in prison. And then when we filed the grievances against the people in the Merrill Lynch case, those just bounced like rubber balls. So, I mean, most of the time the bars are doing absolutely nothing. It sounds like you've got a real renegade on your hands there.
Let's get another question. Right here. Sorry. Yes.
I agree with you that something needs to be done in terms of downgrading the absolute immunity that prosecutors currently have. And have you given any thought what that would look like? Because obviously you don't want to have the type 1 error versus the type 2 error. If you're a prosecutor, there has to be a very high level of immunity or you can't function. The system will break down and you'll take the job. So how would you imagine that standard being set or any sort of limiting condition? And which cases could you go on?
Yeah, I appreciate the question. The question is, if we're going to eliminate absolute prosecutorial immunity, which means you can never sue them no matter how badly they've misbehaved, which I think is ludicrous, what should it look like? Because, of course, prosecutors are in a job where they're going to make enemies. Everybody who feels that they've been prosecuted unjustly is going to try to come after them in civil court, et cetera, et cetera. So a very fair question, a very fair concern. There's different ways of dealing with that. One way would be to have some kind of a commission that takes a look, kind of a first cut, for example, the way EEOC does, and issues, for example, a letter to sue. If they determine that there's a sufficient basis for your complaint, then they would issue something like a letter to sue, where there would be a buffer, in essence, so that not everybody with a grievance and enough money to hire a lawyer can drag a prosecutor into court, but that there has to be a kind of a first cut where someone with the ability and the expertise makes a determination whether there's enough there. I think there are other ways to deal with it, but I would leave you with this. The last body in the world that should be making decisions like things about on policy, like absolute prosecutorial immunity, is the courts. That was just a handout from a supposedly independent third branch of government to their friends over in Article 1. And I guess people probably won't be surprised to find out that one of the surest ways to get to be a federal judge is to serve as a prosecutor in the Department of Justice. That almost without, I'm pretty sure that is the surest way, the best career track you could pick if you wanted to be a federal judge. Definitely don't be a public defender if you want to be a judge one day.
We have questions on this side of the room? Yes, sir.
Question about the immunity that prosecutors hold. When you're saying absolute, you truly mean beyond reproach? Is it above sovereign immunity that's normally held by the federal government and how they control it and for who can sue them?
We don't want to get too bogged down in terminology, but basically with a police officer, there's something called qualified immunity. In order to hold a police officer civilly liable, you have to show that that police officer violated a clearly established constitutional right of yours. They pulled you out of the car during a traffic stop, slammed your face in the ground when you were offering no resistance, and someone got it on tape, right? So they believe your version instead of the cops. That's qualified immunity. Absolute prosecutorial immunity is even higher than that, and it means absolute. A prosecutor cannot be held civilly liable for anything he or she does in his or her prosecutorial function to you, including framing you, suborning perjury, and committing perjury in open court. The one possible sliver is when a prosecutor acts as an investigator or in some non-prosecutorial function. That's an open question still. It appears that you might be able to hold prosecutors liable for that, but courts tend to interpret absolute prosecutorial immunity extremely broadly. You will not find a prosecutor who's been held liable for anything they've done, I can guarantee you.
Before we go to the next question, Sidney, you were a prosecutor, and I'm sure you hold the people that you work with in high esteem. You didn't succumb to the dark side that you all have been outlining here. What is it that creates the temptation to do the wrong thing, and what was it about the U.S. Attorney's Office that you served in that led people to kind of choose the better course?
One of the things I noticed, I worked under 9 different U.S. attorneys from both political parties for over 10 years in 3 different districts, and not a single one of those U.S. attorneys ever told me anything but make sure you do it right. And there were times when some of us would do a better job of representing the defendant in the courtroom than his own lawyer did, much to the chagrin occasionally of some very pro-government federal judges. But that was the way we were taught. And we were taught in the Attorney General's Advocacy Institute religiously to seek justice, not convictions. And if that means a guilty person goes free, that's what happens. Also, we were told to allocate our resources properly. There are lots of dangerous people out there and plenty of crime to fight without looking for something to make up against someone who didn't do it. There are more obvious crimes and dangerous criminals than we can shake a stick at. So we dedicated our resources to the pursuit of the most egregious, true criminals.
So values and tone at the top. John, how are we doing on that front in the Holder Justice Department?
Well, the good news is there is a changing of the guard imminently. Loretta Lynch does have a decent record as a U.S. Attorney in Brooklyn, although there are some spots and ink blots on it that Congress still is asking questions about. I cannot imagine that she would be worse. I can imagine that given the Holder record, she would want to have a relatively quiet 2 years and would want to repair some of the more egregious damages. But if you're looking for structural changes, I don't see her doing that. I don't see any of her answers to the Senate questions recognizing there's a problem. Sidney and I have both written about the Moonlight fire prosecution in California, one of the most egregious examples of prosecutors trying to pin blame for a fire on a lumber company and manufacturing evidence and actually having several prosecutors leave the case because they wouldn't go along with it. Loretta Lynch was not. The Congress has a role to play here. Congress did not ask, very few questions were asked in her confirmation hearing about prosecutorial misconduct, if any. And Clark would probably know if there were any. That's an outrageous abdication of responsibility by our Congress. And of course, many people in the easiest path to often become a U.S. senator or governor is through being a prosecutor. Clark, you know that.
Orrin Hatch did hold up my book to Loretta Lynch for a minute and told her to read License to Lie, and said, clean up the Department of Justice, but there were no serious questions about any of the substantive cases that she could have been grilled on and would have had a hard time not answering.
I want to get back to questions from the audience in just a second, though, but we didn't talk about the case involving one of the speakers here at CPAC, the recently retired governor of Texas, who was indicted by a state prosecutor. And I wondered if anybody could talk about that case.
Yeah,
Do you think that that's an example of prosecutorial abuse?
When James Carville and David Axelrod and former chairman of the Democratic National Committee say this is too far, this goes too far, you know you have a problem. Because there's one thing that people in politics recognize. Politics is a rough game. You bruise egos, you get people mad at you. But if in the course of getting mad at people, you're able to go and convince a prosecutor to mount a charge that basically says the governor of the state of Texas threatened to veto funding if something didn't happen regarding a prosecutor who had misbehaved, then you have reached a low point where everything becomes criminalized, everything becomes a weapon in the ethical wars, and you no longer have elections as the most important determinant of who runs our government. You have prosecutions.
I wrote an article about it in the New York Observer, along with a number of other articles, including the IRS disaster. That's a case that should have been prosecuted under 1519, the fisherman statute that was abused against him. It would be nice if we prosecuted IRS for that. But yeah, I call the indictment of Governor Perry a sham and a shame. It's absolutely ridiculous, trumped-up charges.
Back to the audience. Good question right here. Sir.
As a layperson, I think the comments you made about asset seizure are in trouble. But if you recall an article in the Wall Street Journal maybe 4 weeks ago, written by Alan Dershowitz, where he reflected how he had been basically, I don't remember the details, but basically brought trial of justice without his ever having a chance to respond. That was really scary to me. Maybe if you know that.
I don't.
It was a matter in which he was accused of being associated with sexual misconduct.
I'm aware, but I'm not going to comment on it because the stakes in that case are extremely high. It's clear that somebody's lying. It's not yet clear who, and I'm not going to comment further.
Great. Get over to that side in a second. Right in back, been waiting patiently. Yes, ma'am.
Yes, hi. I just wanted to be clear, when we're talking about prosecutorial immunity, we're talking about civil suit, like money damages. I mean, you guys would agree, prosecutors are still subject to the same grievance procedures that all other attorneys are. I mean, I'm from Maryland, I can think of at least a couple of prosecutors I know who've been subject to that and haven't been disbarred. So, I mean, can you comment on how...
Kudos to Maryland. I mean,
It's a lot rarer than Maryland's experience in most other states.
yeah.
To be fair, it's a big deal. It's a big deal when a prosecutor gets disbarred. I think as it should, because you do have those questions that come up of what, or what point are you...
Let me ask you a question. How many attorneys in the last 10 years of the Justice Department have been disbarred? Well, it's actually a very easy answer, and it looks like the letter O.
Right, well, I'm just thinking at least on a state level, I mean, if y'all could comment on how you think.
I understand the state level, but let me tell you, and I think Clark will agree, there is nothing more fearsome and nothing more powerful than the Federal Department of Justice. And of course, I commend any state that has taken proper disciplinary action. But the mothership, the Death Star, the Justice Department, just in terms of what it can do to a nationwide business or to someone with a national reputation, pales in comparison with almost anything else.
The Ted Stevens prosecutors are still in the Department of Justice. At least 2 of them are still assistant U.S. attorneys. They're the only ones that any sanction was even assessed against. One got a 14-day suspension. The other got a 40-day suspension. Neither one of them served, no, I take that back. One of them served 1 day, and then the internal procedures at the department set both of those aside.
Real quick, I do have, it's very difficult to get statistics on this because, again, there is a wall of secrecy that you encounter when you try to develop this information. But the best article I know of is a 2010 article in the Cardozo Law Review that looked at 2012 accounts of prosecutorial misconduct so serious that the convictions were reversed for prosecutorial misconduct. Of 2012 documented cases of prosecutorial misconduct, there were 37 sanctions and only 2 disbarments. I will tell you that if I worked on a case where the result was reversed because of misconduct that I engaged in as a lawyer at the Institute for Justice, I would be fired on the spot. There would be no discussion, there would just be a box sitting on my desk. And that's exactly how it should be. But it's not when it comes to prosecutors, not by a long
So
shot.
to repeat, you said 2 out of 2,000?
2 out of 2012 documented instances of prosecutorial misconduct resulting in reversal of criminal convictions, 2 disbarments. 1 per 1,000.
So this is a great panel. Thank you guys so much. In our state of Virginia, the governor situation, McDonald, is that compared to the things, the ethics?
Well, look, I don't want to go into that, but I will say this. I find it fascinating that the case in Virginia, which I think had some clear evidence attached to it, was handled at the federal level when under almost all normal prosecutorial standards it would have been handled at the state level. That strikes me as the first curious question you have to ask. What brought it to a federal level for a state governor? Now, interestingly enough, there's an investigation along similar lines about the former governor of Oregon, who was a member of the opposite party as the governor of Virginia was. It'll be very interesting to see how that case is handled and see the comparison between that case and the Virginia case. They're very similar in many respects.
Talk to the Democrat Attorney Generals who signed the amicus brief. The 3 of them that signed it. There was no Virginia law.
There are good lawyers who will respectfully disagree with the Attorney General of Virginia. This is not the first time he would have been made wrong. That's his story, and he will stick to it.
We have time for one more question. Yes, ma'am.
Maybe I'm just naive, but we're all here because we're activists in some form or fashion. And you've given us a lot of problems.
So the answer is, should we be scared? Is that your question?
We're already that.
No.
But we're not scared, and that's what we're going to stop doing what we're doing. What I want to know is, what can we, the people, do? What can we, the people, do? We're the ones that should have the power here.
Well, the first step should be, and it may be too late, but at least they should know, we should let our senators in Congress, the senators, certainly because they handle the confirmation, why in the world was none of this brought up in Loretta Lynch's confirmation hearing? Should it be brought up in the confirmation hearings of other people who will be confirmed at key roles in the Department of Justice over the next 2 years? Congress has surrendered so much of its power to independent agencies like the FCC, which today declared net neutrality, despite a long history of courts saying that the FCC did not have jurisdiction in this area. Congress has abrogated its rights and responsibilities as an independent branch of government. One of the things we can do, since we elect the people's representatives, is we can put pressure on them and say, do your job, do your oversight function, and that includes the Department of Justice.
We can urge Congress to give more power to the inspector generals. We can also urge them to pass legislation that would require open file discovery in criminal cases, and there is going to be an effort. Senator Hatch and Senator Lisa Murkowski from Stevens State of Alaska are going to reintroduce something akin to the Fairness and Disclosure of Evidence Act that was widely supported by everybody from the ACLU to the National Association of Criminal Defense Lawyers when it was introduced a couple of years ago. The only entity that opposed it was our now ironically named Department of Justice.
I just want to intrude on Reg's prerogatives as moderator and mention that all 3 of us have written books on this subject. Mine's Obama's Enforcer, inside the Eric Holder Justice Department. Sidney's is Licensed to Lie, and Clark's is
Terms of Engagement.
And all of them are downstairs in the exhibit hall in the book room.
Yeah. And I'm going down after this and will sign one that anybody wants.
Well, I want to thank our panelists for a really exciting conversation. In terms of what you can do, paying attention and shining a spotlight on problems when you see them makes a difference. I was thinking about a state case, Mike Nifong. Remember the fellow that went after the Duke lacrosse players? He was disbarred after the facts came to light and there was a public uproar about it. So staying engaged and shining a spotlight on issues when they are there, I think is a really important thing to do. I'd be remiss if I didn't say again that I think most people believe that most prosecutors are trying to do the right thing to keep our communities safe. Sometimes they get attacked. Ferguson comes to mind for doing the right thing and declining to prosecute when there is no case. And we're all very grateful for the work that those good prosecutors do. But when a prosecutor does go wild, it's probably a good thing to focus on it and to think about solutions. And I want to thank our panelists for doing just that.
Thank you. And on a personal level, remember the presumption of innocence. I'm guilty of this myself. I read about something in the newspaper and I think, oh my God, you know, they're just completely guilty. Well, until you've looked at the facts of a particular case, you can't really make that determination. And the second thing is, welcome jury service. You know, we all get those notices. We think, oh my God, it's going to take this time. But a single juror is the last bastion of democracy. A single juror can stop an unjust criminal conviction. And it's one of the most important things we can do is to welcome jury service and encourage our neighbors to do the same thing. Thank you all so much.
And if anyone wants some information, a short review of my book, it's being passed around there, and feel free to grab one.